Let's talk about why anybody would ever want their estate to go through probate, because there are ways to set up and to avoid a probate. I mentioned the revocable living trust route. That is a way to avoid a probate if it's done correctly. In Washington state, particularly when it comes to married persons, if they want to make sure that they leave money for their spouse, one of the best ways to do so is through a will that contains an asset protection trust. Let me tell you what I'm talking about. At ELG Estate Planning, we do estate planning and elder law. We help clients with long-term care issues. We help clients qualify for Medicaid. We have Medicaid expertise. Oftentimes, we will recommend to our clients that if they are a married couple, that they put in their wills what is called an asset protection supplemental needs trust. This is how it works. An example is probably the best way to explain it. Let's say we have a couple and they have $1 million, $500,000 in their house and $500,000 in bank and investment accounts and such. And they are concerned about long-term care costs, rightly so, because the number one threat to any senior's financial security is long-term care expenses. So let's say we have a couple, they're in their 70s, and maybe they don't have any diagnosis, but they know that long-term care is something that they're worried about. So their wills will each contain this supplemental needs trust. When the first spouse passes away, their half of the estate, remember we're in Washington, so it is a community property jurisdiction. So as a general rule, half is owned by one spouse, half by the other. The first spouse dies, their one half of this $1 million is going to go through the will, through the probate process, into the supplemental needs trust for the surviving spouse. What is the benefit of doing that? The benefit is that no matter what happens in the future for this surviving spouse, they will always have protected from creditors and from long-term care costs and from Medicaid eligibility and spend down that $500,000, one half of the combined estate. The deceased spouse's share will be in this trust. Because it's in the trust, it will not need to be spent down before the state will pay for long-term care for the surviving spouse. So to put it into perspective, this couple, one of them dies and the surviving spouse has dementia. And because they have dementia, they will not be able to live on their own anymore. Once their spouse has died, they're going to need to move to a care facility, memory care facility, an adult family home, somewhere where they will be safe. So if that is a situation when the first spouse dies, then through the probate process, what we likely would do is we would take and put $500,000, that is the cash element of the couple's estate, into the supplemental needs trust, leaving the house in the name of the surviving spouse. Under Medicaid's rules, a house is not a countable resource. So the surviving spouse is eligible for Medicaid immediately without any spend down, despite the fact that they own a house that's worth $500,000 and they have $500,000 in a trust. So you may have some familiarity with Medicaid's rules that a single person can only have $2,000. Yes, they can have $2,000, plus they can have $500,000 in this trust. The only way that they can have this $500,000 in trust is if it was created by their spouse's will, not by a trust. A revocable living trust doesn't achieve this result. If this type of asset protection is attempted through a revocable living trust, the state won't honor it. It has to be done through a will. And since it's done through a will, there must be a probate. So yes, there was a will, there was a probate, there were legal costs involved, and there's $500,000 protected. That is one of the reasons that your estate planning and elder law attorney might recommend to you to use a will, to use this asset protection supplemental needs trust. So if you hear the term probate, don't think, oh, that's a terrible idea. Ask the question, why would I be interested in doing a probate? How would that benefit me? There's a lot of other reasons to do a probate, to make sure that there's an orderly administration of the estate. With a revocable living trust, often an attorney isn't involved, so it may not happen that the trust is administered properly. Also, with a probate, there's an easy mechanism to get rid of creditors that shouldn't be paid, that don't need to be paid. With a probate, you're more likely to make sure that if you have a taxable estate, that your credit shelter bypass trust is set up. Let me explain what I mean by that. The federal tax level is over $12 million currently. If that is your situation, I'm guessing you are working with a tax planning attorney, as you should be. For people who are under the $12 million level, you don't need to worry about federal estate tax. If you live in Idaho, you are at the federal tax level. Idaho doesn't have an estate tax, but Washington does. And as I mentioned before, it's $2.193 million, which if your house has appreciated, even if it was very modest when you bought it, but now it's worth, $1.5 to $2 million, you have some concerns about having a taxable estate. So with a couple, there is not a tax imposed on the death of the first. And for that reason, sometimes it's overlooked that on the probate of the death of the first spouse, a tax trust needs to be funded. Now, it can be funded through a revocable living trust, or it can be funded through a will. If it's funded through a will, it's sometimes called a bypass trust or a credit shelter trust. The whole purpose of this trust is to make sure that you take advantage of that $2 million tax credit that your spouse has so that you don't need to pay it on your death. For example, the couple has a $4 million estate. First spouse dies. $2 million is going to fund that bypass tax trust. So when the surviving spouse dies, they only have their own $2 million, which passes to their beneficiaries tax-free, as does the amount that is in that tax trust that was funded on the death of the first spouse. So this $4 million goes tax-free, estate tax-free, to the beneficiaries. If, on the other hand, this tax trust wasn't funded, then the surviving spouse ends up with $4 million. And when they pass, $4 million will be in their estate, of which only about half of it goes tax-free. So there will be a couple $100,000 in unnecessary estate taxes paid, all because the couple didn't understand estate planning or didn't seek out the services of the attorney, or they had a revocable living trust to avoid probate, so they never looked for help when the first spouse died, so they never funded a tax trust that was in their trust, but they never did the work to fund it. And as a result, they're going to end up paying a couple $100,000 in unnecessary taxes. So this is the reason that I think it's really important to share this information, that it is definitely a benefit to have this understanding for long-term care purposes, Medicaid purposes. Whether or not you'll ever use Medicaid, it gives clients a great deal of reassurance and peace of mind to know that no matter what happens, they'll never leave their spouse impoverished, because they'll leave them with this asset protection trust. Or if we are working with clients that have a taxable estate, that there won't ever be unnecessary estate taxes paid. So I started out by saying how important the living documents are. These documents that take effect upon your death, your will, or your revocable living trust, are also very, very important.